Okay. Well, good afternoon, everyone, and welcome to the latest in the GLS series of masterclasses. Today's webinar is going to be focusing on the topic of contracting playbooks. Now, before we kick off with the presentation, just a couple of quick house rules. Can I please ask you to submit any questions that you have through the chat function? We'll then address as many of those questions as we can at the end of the presentation. You do not have the option of speaking during the presentation, so please just think of good questions and submit them, and I promise you that we'll get to them when we can. So with that, let's start. During the course of today's presentation, we're going to be focusing on what exactly is a contracting playbook, why are playbooks used at all, what are the design features that you'd expect to see in a best practice version of a playbook, how to use a playbook safely, and how to implement playbooks into your organization. So let's start with that all-important question. What exactly is a playbook and why are we using it? Well, simply put, a playbook is a user-friendly guide that helps you drive optimally efficient contract negotiation processes. Now, this seems very pleasant, but also reasonably bland. So you might ask, what exactly is all the fuss about? You might ask, why do high-performing in-house legal teams bother using playbooks? Well, the answer to that is that a properly prepared playbook drives better, faster, safer, and far more cost-effective contracting. So let's unpack that idea a little bit more. Firstly, let's consider this concept of efficiency and what we mean by it in contracting and how playbooks help. Specifically, playbooks bring efficiencies to your entire contracting process. They provide standardized arguments, positional guidelines, escalation protocols, and negotiation strategies to your negotiation team so that they can be used to drive forward negotiations and reduce the time to close your contract negotiations. Very importantly, playbooks enable... Can I ask everyone who's still speaking to put yourself on mute during the presentation? Thank you very much. Okay, consistency. Playbooks ensure that your organization is asserting approved positions consistently in every contract negotiation scenario. The point here is that these issues are important to your business, so you need to be able to reliably ensure that they are forwarded and pressed and negotiated for in every contracting scenario. And your playbook is one of the most efficient tools to enable you to be confident that that is, in fact, what is happening within your organization. The key issue of playbooks, and the reason why I'm sure you're all here, is that playbooks allow basic contract negotiations to be delegated safely and efficiently away from the more expensive members of your legal team. Thereby, you free up the capacity of your more expensive lawyers so that they can do that higher value, more strategic work that you want them to do and that they studied so long and hard in university to be able to do. You're using your playbook to enable your one-year PQE lawyer or even your business unit to negotiate the NDAs and basic procurement contracts so that your 15-year pre-QE lawyer has enough capacity that they can actually focus on those major M&A deals, major litigations, major new territory expansions that you actually get value from them doing. Risk mitigation. Your playbook provides clear risk assessment frameworks that help you to identify potential risks and provide strategies to minimize those legal, commercial, and operational risks. Playbooks provide you with compliance assurance. They ensure that regulatory guidelines and compliance standards are met, and that you can take confidence that there's a consistent approach to those compliance obligations across the entire portfolio of contracts that your company has entered into. An often underrated aspect of a playbook is that it enables you to capture the know-how of your legal team. So with a well-designed and well-maintained playbook, you're going to be regularly capturing the best tips, tricks, and responses that your negotiation team come up with, so that those tips and tricks can be leveraged for the benefit of the entire team. So the net result being that not only is the ostensibly worst negotiator in your team operating to the same high standard as the best negotiator in your team, but it also protects your department from brain drain if that best negotiator ever leaves your team. So your worst negotiator is not only operating to the standards of your best current negotiator, but they're working to the high standards of your best ever negotiator. The net result of this is obviously that shorter contracting cycles and reduced legal costs result in cost savings. Ultimately, the thing that probably matters most to the people who are signing the checks to get a playbook in the first place. A key issue with contracting within larger organizations is the frustrating process required around approvals and escalations. When do those escalations happen? How should they happen? Who's responsible for doing it? Who's responsible for policing it, etc., etc. Playbooks help you to establish a streamlined approval workflow that prevents those bottlenecks and ensures that the right stakeholders are reviewing the right issues in your contracts at the right time. It thereby enables enhanced collaboration between the various teams or stakeholders involved in a contract negotiation. You have standardized processes and templates which facilitate cross-functional team collaboration more efficiently on contract-related tasks. And finally, as a result of all of this, you'll tend to find that you've raised the profile of your in-house legal team. You've taken a big proactive step to address the thing that is causing your business units the most frustration and reducing the morale, i.e. that the legal department is becoming a bottleneck to them doing more of the business that they're getting remunerated to do. You are removing a perennial complaint. You're contributing to your company's ability to do more deals to a higher standard more efficiently. And as a result, your business units are happier and your business units have a better, more positive relationship with the in-house legal team. Really, this is a win-win-win for all concerned. Now, we've cantered through some really nice positive aspects of Playbooks there. If you are interested in this aspect, like you're trying to build an argument for your in-house stakeholders as to why you should be introducing Playbooks to your organization, you can read this blog recently published by GLS, which gives you 20 further reasons about why contracting Playbooks are essential. So let's move on to our design principles. Ultimately, what goes into your playbook is a decision for you. However, for every organization, there are always going to be three primary drivers of playbook content. Firstly, utility. Your playbook must contain enough content to be useful to the anticipated user community. The user community itself is important. You need to consider who those users are, and your playbook design must reflect the needs of that user group. Note that not all user groups are the same. A playbook for your in-house lawyers might be quite different from one for your frontline procurement personnel. Finally, confidentiality of your playbook is extremely important. These are the crown jewels of your legal team's know-how and the kind of secret sauce to your negotiation success. So playbooks should be kept as extremely confidential, important, valuable assets within the business. Now, active consideration and appropriate calibration of these three primary drivers is the most essential step in producing an effective playbook. Then let's explore what the number one golden rule is that should be observed when you're developing a playbook that works for your legal team. So, what is that golden rule? Firstly, some clues for you to all think about. Craftsmanship turns simple tools into instruments of brilliance. And before engineering the skyscraper, we must lay the first brick with care. So, what is that golden rule? A golden rule is that you must start with a modest tool or a modest playbook in this quote. That is, playbooks are extremely exciting and are incredibly powerful tools. So there's often a temptation to jump into creating a behemoth of a tool that addresses every possible contracting issue or scenario that your procurement team might ever come across. That is a very understandable and appreciable desire. However, it is far more important to start with a simple tool that works 100% of the time that it's used. And you can then build on that over time. So our GLS advice for the day is start with a simple toolbook and build from there. Now, when we talk about building from there, let's look at some granular design rules for that tool. What exactly should you be considering when you're designing a playbook for yourself? Firstly, your playbook should be calibrated to your paper, i.e. your in-house templates. A playbook is not a checklist for the review of third-party paper. Okay? This is something that you should negotiate to help your team negotiate something that they're familiar with and that they use all the time. You want to be focusing on addressing the clauses within your templates that are the key arbiters of risk and drive disputes globally. So for us, GLS, we tend to cover 10 key arbitrators of risk, plus give some extra advice around those generally irritating supplier comments. The length of your playbook should be as short as humanly possible. Should also be as beautiful as humanly possible. The point is that this is a tool that must be used. It must be a very pleasant experience of your frontline procurement negotiators to actually open up and use this tool on a day-to-day basis. So this is a case where fashion does go hand in hand with function. Now, you should be looking at what are your answers to those key points, not including every possible discussion on any possible issue. The idea is that you have, within your contracting function, you have a number of different tools and resources available to answer questions. Not everything needs to be dumped into your playbook. You've got FAQs, you've got helplines, you've got all kinds of resources. So keep your playbook simple, beautiful, easy to use. Speaking of easy to use, visual design elements to aid understanding and aid usability are preferred. So for example, in the GLS playbooks, we color code every clause by reference to one color for what can never be changed within the clause, one color for things that the concept must remain, but we're fairly flexible about the exact language used to achieve that concept, and one color for things that are nice to have, but we're not particularly worried about if we can't have. Your playbook design notes and guidelines should be as simple as possible. You should be using plain English drafting here, and the language must be brief enough that it can be used during real-time negotiations. So we're trying to avoid paragraphs and looking for short, succinct bullet points. The utility of your playbook is that you should be looking for a playbook to address your most commonly used commercial agreements. So do not create a playbook that is designed to capture every possible contract that your company may ever enter into. Design your playbook to address the things that your company does 80% of the time. Okay. So now we must decide what exactly is information that we include within our playbook. What you decide to include in your playbook is a personal choice to yourselves, but what is on the screen is what is typically considered to be best practice for playbook design. Your playbook should include key clause issues, how each of the key clauses in your standard contract works. We should be looking at industry risk indicators, i.e., what is the acceptable industrial risk or market risk in relation to each of those clauses? What is your negotiation strategy for each of those clauses? How flexible, how much bend or twist, how much negotiability applies to each one of those clauses? What are your positional justifications? Like, how can you negotiate and successfully win an argument over the inclusion on any particular element in each of your key clauses? What are the escalation pathways that should be followed in the event that you are not winning that argument? What are the typical arguments that are raised by counterparties and how best to respond to those arguments? Who are the internal experts within your organization that a negotiator can reach out to if they ever need expert advice or support? What are the typical irritating strategies used by common annoying counterparties and how best to overcome them? Identify business sensitivities. Are there any specific issues that your negotiators need to be aware of and address during their negotiations? And golden rules. Basically, golden rules are there because it's always very helpful to distill a negotiation approach into a memorable, digestible, succinct rule. For example, warranties are there as we require our suppliers to stand by their service performance. Simple, short, brief. Again, how you ultimately slice and dice your playbook is a matter for your organization and your particular team. But if you ensure that there's active consideration of the appropriateness of including each of these elements, you will be fairly certain that you've developed an excellent playbook that at least covers most issues most of the time. So now we've got our playbook up and running. We understand the need for it. We understand the key concepts that should be included in it. How can we be sure that we're using it safely? Ultimately, a playbook is a tool. And to get the most of your tool, your user group must use it in the right way at the right time. A hammer might be a fantastic tool, but its performance will always be suboptimal if you're trying to use it to unscrew a screw. So there are a number of safe usage rules and principles that you should keep in mind to help you to maximize the productivity potential of your tool for you. Specifically, your playbook should be aligned with your group legal policy. There should be clear and consistently applied access controls to who can use the playbook and in what format they can use it. Within your playbook, there should be a very clear usage scenario set out. So this is a screenshot from one of our playbooks saying this playbook is specifically to be used for short service agreements with a value of less than $250,000, etc., etc. Your user group must be extremely clear that this playbook is not to negotiate your employment contracts, for example. Finally, it's a tool, so your users are going to need to be trained on how to use it. This training is fairly easy to do. It's just a quick 1-hour presentation with some live workshopping or kind of exercises to make sure everybody understands it and is using it in the right way. But spending that hour up front means that you will have a tool that works to save a lot more hours in the long run. Stakeholder involvement is key. Now, when you're designing your playbook, ultimately it's the legal team that is going to be holding the pen on the design of the playbook. But like anything being implemented into a large organization, you want to ensure that the stakeholders involved in that project have been able to provide their own input into that project so that they are invested in it and so that the tool is suitable for the user group that you intend to use that tool. So stakeholder involvement is important, but we'll come to discuss in more detail later how this is not meant to be a tool that should be designed by committee. We'll park that for now and come back to it later. Finally, your playbooks are live tools. These are not to be frozen in time. So they should be regular updated, and those updates should be taken by way of systematized protocols. You want improvements to capture the new know-how and best ideas of your team, and you want improvements to capture changes in law, changes in your group legal policy, or changes in the market. Okay, so how do we go about implementing a playbook into our organization? What exactly does a playbook project look like? First, you need to start by picking what are the target clauses that you want your playbook to address. As mentioned, at GLS, we take a 10+2 approach. The 10 key clauses that define legal and commercial risk within a contract, plus 2 points to deal with additional considerations such as remedies and those typically annoying generalized comments and strategies raised by counterparties. Your playbook should then be defined by reference to your group legal position on those clauses. When we're doing this kind of design, it's remember to keep Pareto's principle in mind. That is the 80-20 rule. You're preparing your playbook not to try and anticipate every possible argument and pushback scenario that could ever possibly arise in your team. Rather, you're aiming your playbook to cover what happens 80% of the time. You want your playbook to ensure that the common, basic, often repeated issues are addressed perfectly every time. And you can leave those rare exceptions to be dealt with as special projects as and when they arise. Oops, sorry. You then build your clauses. You want to draft your standard clauses, both the long and the short form version of those clauses, and define your positional tolerances in relation to those clauses. What is the ceiling that you're aiming for? What is the floor that you will accept? You want to define your legal baseline and suggested positions on all of your, legal baseline. It's the legal team that is defining the suggested positions and what position your playbook should be taking on all of its content features. As mentioned, this is a tool that should be designed as a collaborative effort. However, that does not mean that this is a tool that should be drafted by committee. This you should be seeking stakeholder input so that they're engaged with the project, they're excited about the project, and so that the playbook is effective at targeting the issues that your stakeholders are raising. However, this is not something that should be a major hurdle to your project or something that causes a huge amount of slowdown to your project. You should just be giving opportunity for comments and to engender engagement and excitement. But this is not the thing where you end up waiting years before you get feedback from everybody. Finalization. Again, your legal have set the baseline. You've got engagement from your stakeholders. It is then the legal team's responsibility to finalize the playbook and draft it along with your user champion. Like any major project within a legal department, you should then deploy it amongst a small group of supportive users and do some pilot testing. Take the feedback from that pilot testing and improve your playbook so it's ready for the live environment. You should then do some user training so that all of your user group are aware of and understand how the tool is meant to be used in that live environment. You then roll it out to the live environment and you track the performance achieved by that tool. You want to obtain objective, verifiable data to show the impact of your playbook on your contracting function so that when you explain your successes to the board at the end of the year, you've got real numbers that they understand to show that your ideas have been successful and that your ideas have contributed to the ongoing success of the business. Finally, do not forget to have a maintenance program and protocol for your playbook. This is a live document that should be growing and evolving with your team over time. So, some conclusions on this fantastical tool. Playbooks are essential for contract function optimization. It's as simple as that. They allow compliance, cost control, productivity, risk management, and performance improvements. The design of your playbook should focus on utility, the user group, and a way of ensuring its confidentiality. When in doubt, go simple. Start with a simple tool and build upon it as the success that tool is validated. Speaking of validation, this tool is going to have a material impact on the contracting function within your organization. So be sure to track that in some objective way that you can validate that performance to your key stakeholders. Numbers are the language of business. So record some basic numbers around the time taken to close the average contract within your business before and after introduction of a playbook. Record, for example, the amount of legal man hours involved in each contract negotiation before and after the playbook. Show some things that produce some numbers that you can show to your CFO so that he is as happy with the performance of your playbook as you are. It is a tool, it's a complex and it's a powerful tool. So like all tools, you do need to ensure that your user group is properly trained on how to use and maintain the tool. A good playbook, well, the final most important conclusion is that a good playbook does take time to produce, but it is a sound investment. In fact, it is one of the most potent, most cost-effective ways to optimize the productivity of your contracting function and legal team. Simply put, you cannot be serious about legal department productivity improvements if you're not implementing playbooks into your day-to-day operations. Okay, a bit of log rolling to finish the presentation with. Anyone can prepare a playbook for themselves, but preparing one from scratch does take some time. Indeed, poorly run playbook design programs can and often do particularly in larger organizations, drag on for months and even years. This seeming black hole of in-house team time is typically a function of suboptimal methodology, and regardless of how right or wrong the production of your playbook ends up being. So projects and playbook implementation projects often wade through typical treacle in larger organizations, frustrating engagement with stakeholders, too many chefs in the kitchen kind of syndrome, etc., etc., etc. So, in an effort to save you time, GLS has already produced what is considered to be a world-class best practice playbook that's ready to go. This is an off-the-shelf product that costs a few $100s rather than a few years worth of time. The idea is that you can take the GLS playbook and have 90% of the work done, so that all you need to do to implement the playbook safely and effectively into your organization is do some minor nips and tucks and tweaks to make sure that it's bespoke for the needs of your organization. If you are interested in a GLS playbook, you can visit the GLS Legal Operations Center at gls-legaloperations.com, or you can scan the QR codes, which will instantly register you to have an account on the Operations Center. And with that account, not only will you have access to the GLS playbook, but you'll also get a free welcome pack, which is stuffed with about $5,000 or $6,000 worth of legal operations resources. So with that, I'm going to draw the presentation to a close and open the floor to Q&A. If you do have any questions, please now raise them.
Nick, can you hear me?
I can, yes.
Yeah. There's a few questions that have come through. The first question is, it reads, why is it challenging for an in-house team to build their own playbook? Aren't they well placed to do so?
That's a very good question. And there's two elements to that. First, an in-house team is extremely well placed to ensure that a playbook is designed to effectively address the concerns of its business. In fact, they are the only people that are effectively placed to address the needs of their business. However, playbook design is much like any other project raised by an in-house legal team. It's something that ends up being done on top of their day jobs. So it faces the typical problem of anything that's done after the day job is complete. Namely, that in-house legal teams' day job already sucks up their evenings and often sucks up their weekends. So they never get free enough to find the time and capacity to do the research and the drafting, et cetera, required to produce a playbook. So the resolution to that situation is what GLS has done. We have produced a global best practice playbook that can be taken off the shelf, thereby saving a few hundred hours of design and research and optimization. The in-house legal team can then take couple of days to implement that to the exact bespoke needs of their organization. You're saving time, but getting the benefits of bespoke crafting. And that would be my approach to this question.
Nick, I'd probably add a few other little points on that, if I may. It's Matt Glynn here. I've found, particularly when we're implementing playbooks into the larger organizations, the whole process, the initiative itself is one in plate tectonics. That is that the process can reveal fault lines that might not otherwise be obvious. Quite often, the contracting function has multiple owners. There might be a procurement team, there might be an overly assertive or authoritative finance team, there's legal. And the process of actually coming up with a tool which is designed to support all internal users can actually be quite a fractured and disruptive and abrasive process. There's a couple of other challenges there as well, sort of building on your team, your point about, in-house lawyers being busy and their capacity being short. The whole process of collecting and moderating content from all your different internal stakeholders, it's a unique skill unto itself. It requires an absolute amount of time, but there is a skill to, if you will, tell the more senior figures in your legal team that perhaps, their comments are not really anything more than sort of stylish language preferences. I mean, we've worked on multiple projects where you've got 6 people all saying things a different way. The quick brown fox jumped over the log, or the log was jumped over by the fox with a bushy tail, etc. Trying to keep comments substantive is a challenge. I'd probably also add a couple more points. Resourcing, the whole process of defining, calibrating, selling, training, arranging workshops and all that sort of stuff. Is that necessarily what you want your high value lawyers, your high cost lawyers doing? So the team's got to have the capacity in terms of additional team members to come in and provide this support. And then really just to add to a point that you did touch on earlier is the too many chefs phenomenon. I mean, one thing about our in-house community is that we're never short of things to say. Everybody's an expert, particularly when you put a draft in front of them. So we all know what happens when to the broth when there are too many chefs. So the ability of having a really important or really well robustly developed starting point, well, that actually brings out the best of lawyers, because lawyers comment when they're reading a document with the pen in hand, so you can get comments. But also having a third-party voice that can kind of short circuit or cut through some of the internal dynamics that might not necessarily allow the project to be conducted as qualitatively as possible. So there's just a few additional thoughts, but I guess the key point is that, the one that you made is that it's your ecosystem, it's your tool, no one's better placed than you, but ultimately it's the perennial in-house challenge. All too often you're too busy to find time to step back to become less busy. So that's the kind of solution scenario that we're trying to help with. We did have another question, Nick, which was, how long does it typically take to deploy a playbook, which is an interesting question.
Yeah, it's a good one. And to some extent, it does depend on the organization that the playbook's being deployed into. The quickest I think we've done is in about 3 weeks, and the slowest was over about 4 or 5 months. There's not a huge amount of difference in the amount of work between those two extremes, but it does depend on finding the way to manage the change within the organization efficiently. So on a project that takes a number of months, the challenge is to capture everyone's attention, keep them attentive, and make sure that they're aware and available to make comments as and when you need them. And when that breaks down, it takes longer. For a short project, you're effectively maximizing the organizational design to achieve your outcomes. You're capturing everyone's attention as and when you need it. You're consolidating feedback, and then you're executing that feedback quickly. And yeah, it's both are valid. It depends on the needs of your organization, really.
Thanks. We've got a couple more questions that have come through. I commend the audience member that submitted this question. It's a very important one. And they say, doesn't a playbook require you to first have a group legal policy in place? And if you don't, like our organization, does that mean that you are unable to produce or take advantage of a playbook tool?
Yeah, it is a very good question. And if you've seen some of GLS's other presentations, you'll know that from the GLS perspective, every legal operations tool and process is built on the foundations of your group legal policy and should be referring back to that group legal policy. However, I would slightly challenge the statement that their business does not have a group legal policy. Every business does have a group legal policy. The problem is that some group legal policies are properly and well documented in an approved format, whilst other businesses, like probably the organization of the person asking the question, that group legal policy is scattered across the brains of in-house lawyers and certain stakeholders within the business. So your challenge when designing the playbook is, how do we capture what that group legal policy is to design the playbook by reference to? And I would say that in such scenarios, documenting your group legal policy is a key first step of the playbook design process. If you want to use the GLS straight off the shelf playbook, you can effectively kind of hang on the coattails of what we consider to be a general world-class best practice group legal policy. But even in that scenario, we should be interrogating what is the actual group legal policy of the business that the playbook's being implemented into. And as a first step, documenting that group legal policy, at least in relation to the clauses that are going to be addressed in the playbook.
Yeah, that's certainly our experience, is that the absence of a full group legal policy that deals with everything that the mandate of the legal team is required to address is not a fatal barrier. Obviously, formulating a comprehensive group legal policy might take months, if not years, and I think that probably explains why more than 80% of in-house teams that we deal with don't actually have a formal group legal policy. But the moral of the story is that which underpins legal operations and in-house legal team performance is you need to be practical, you need to be flexible, you need to take an innovative approach. So you can absolutely push on with your playbook project immediately, but in so doing, you can actually knock off some of the vital elements of your group legal policy. So in our 10+2 scenario, we could workshop with a client for 60 to 90 minutes and obtain for them, by extrapolating it from their heads through Q&A, what are their positions on those 10 points, whether it's termination, liability, indemnity, warranties, etc., and document it. And the playbook development process continues in line with the critical success path. But as a residual byproduct is that now the playbook project itself has created a valuable input for a growing or emerging group legal policy. So I think it's a good example of how transformation related work needs to sort of be done efficiently and practically, and sometimes in a seemingly reverse order. Nick, we've got 2 more questions that have actually come through.
Sherry has actually raised her hand, so I'm going to take Sherry off mute, and then the floor is yours, Sherry. How can we help?
Thanks, Nick. Thanks, Matt. Yeah, so I heard your training. I'm just wondering, right? You also mentioned you have a already made off-the-shelf playbook, but you can also help to do the customized playbook.
Yep.
And I'm quite interested in understanding how it works. If we wanted to use the customized playbook. Another question is, of course, every playbook needs to be short and precise and nice to read, right? So my understanding is each of the playbook usually addressing a particular template. So usually when a company is having multiple templates, do we typically produce multiple playbooks, or how should we do it more effectively?
Yeah, that's a good question, Nick. Maybe I'll just jump in and Sherry will start with the second question. If it's your first foray into Playbooks, then our strong suggestion is you want a tool that can achieve maximum productivity ripple effect across all of your contracting scenarios. That's point one. Point two, in-house legal team transformation and performance optimization is about Pareto's rule. The moment you try to cover a solution, whether it be a CLMS system, a checklist, or a training session even, to cover every single conceivable nuance, variation, and the like, then the solution or the initiative will come to a grinding halt. So for the first foray into Playbooks to really make a tangible contribution to contract function optimization, we recommend Pareto's principle. Your 80% scenario commercial agreements, I'll give you 5 off the top of my hat: services, consultancy agreements, NDAs, supply of goods, SaaS agreements, etc. As an example, they are all of a similar species. And inside those agreements, Pareto principle will tell you that your position on those 10 key legal issues, IPR, termination, data protection, indemnities, warranties, etc., will be and should be the same. So we suggest that for your template library, when I go in and audit review your documents, I should see by and large the same approach to liability, the same approach, the same language for the notification provision, the same language for the waiver provision, etc. There should be consistency. And if your templates are structured like that, and if they're not now, then they should be in the future, right? The first playbook should speak to those 10 key points. That then means that the single playbook has application for your entire commercial suite that falls into that 80% scenario. Now, going forward, once you get success, and as Nick has advocated in this session, success that hopefully you've documented and shown through empirical data, you can continue on with your journey, and maybe you'll find, say, for example, if you're in a spot commodity trade scenario, or if you've got a really complex service offering which requires genuinely unique terms and conditions, and the volume is such that it warrants a specific playbook scenario, we would say, with the foundation you've established on your generic issue playbook, then the case for that would be there. But start with maximum productivity ripple effect. As to your first question, the customization, what does that look like? Well, again, Pareto's principle plays a really strong, it's a North Star in legal team optimization, right? We're not trying to cover every scenario, it's what happens most of the time, right? If we can get that right, then our day frees up to focus on the more complex value-added stuff that legal counsel should be focusing on. So if you take a standard GLS playbook, it's pitched around that 80%, which is a sensible commercial entity will be advocating for balanced legal risk, typically calibrated according to a sector. And when you view it through that lens, where parties tend to end up on most of legal issues tends to be there or thereabouts, okay? Most parties will not want to accept liability for indirect loss. Most parties will not seek to cap liability for death and personal injury, apart from the fact you can't do that in many jurisdictions under law. So with the generic playbook, what you've got is access to a playbook that probably takes you 80, if not 85% down the road of developing positions that a sensible organization would be likely to embrace, which means that you've got, and you do that in 10% of the time and cost, which is a massive catalyst for efficient momentum of the project. And then obviously to squeeze that last 15% of productivity, you start calibrating it to the unique language and isms of your business. Say, for example, if you're a SaaS provider, you're going to have certain, your business financial economic model is going to be that you can't necessarily offer tailored caps on liability and specific warranties to your end customer, right? Because if you start doing that, the economics of the model of, you know, here is the same standardized product for everyone, take it or leave it, doesn't work. So in those situations, you know, it would be appropriate to customize your playbook by augmenting your position by reference to, well, this is why we advocate the position should be X, and you build that out by reference to your organizational experience and your sector experience, etc. So I guess just to reiterate that in 2 points, we are unashamedly committed to balanced, sensible risk allocation, right? Our standard playbook positions might not work well if you are a UAE government institution where, you know, they're still asking the suppliers to provide, you know, performance guarantees that have no conditions at all other than the submission of a request for funds. Your playbook's not going to work. Our playbook's not going to work in that solution. But the second point is that playbooks, like Nick said, it's a living, breathing, dynamic solution that should continuously be improved. So you should be augmenting by reference to specifics about your business model, specifics about your own counterparty experience, sector, and for those that are in different legal jurisdictions, you know, the law itself. Sherry, does that give you some color in respect of both of those points?
Yeah, thanks. Yeah, I think I generally understand what you mean. I'm just wondering whether you will allow us to have a peep of your best practice playbook. What does it really look like?
Well, we can to anyone who's on this call, we can send you a chapter. Okay, we can send you a fully worked up chapter, and you are more than welcome to take it, use the structure, and populate it with your own content and build it out for all your clauses. Again, the key solution that we're solving here is, you know, GLS is not saying we're the only clever clogs out there. Far from it. The point is that the perennial operating conditions the in-house community have is just simply what's coming into the inbox is too great. And quite often inside an organization, you know, your ability to workload balance can, you know, depend on who's asking you. And it's really just about freeing up capacity and making sure that when you pull the trigger on an initiative, you can see it through in a time frame such that the internal audience actually, you know, sits up and goes, okay, right, I can see they've done this. Let's get behind and support it. So yeah, anyone that would like to access a fully worked up example chapter of our playbooks, by all means, happy to share.
Thank you very much. Sorry, you know, based on what you just told me, I have another question, because we do have a group that we have different business units, right? In each of the units, they have different product model, different business model, and they might even have different bargaining power, right? In the process of negotiating with their counterparties. And for us, we do feel that a lot of the time the contract are not so standardized, right? Like sometimes we had to review the counterparty templates. You know, I can understand, you know, if we have a playbook that covers the indemnity, warranties, data privacy, you know, those common clauses that should solve some of the issues, but a lot of the issues we're facing are also coming from the pushbacks, right? Obviously, the best practice playbook usually set out a balanced, you know, position that both sides are likely to accept. But on the other hand, we do see quite a lot of situations where the other side really just wanted to insist it on some kind of quite one-sided argument, and usually those ones will have to go to me, or, you know, we have to even go to the management for further approval. So I'm just wondering, right, that the playbook, at least for our group, it may solve maybe 30% of the issues, because majority of the contract that we're facing, they are subject to all this review and separate consideration. So I'm wondering whether you also have any tools to help with those information for that.
Absolutely. Let me just let me explain in 3 steps how we approach, right? A little bit like Cinderella. We've got to find the foot that this magical slipper fits. So step 1, there are 2 types of contracts according to GLS. There's long ones and there's short ones. It's legitimate. Okay. Point 2, there's, if we view it through a point that you raised, a bargaining position, if we look at it through the negotiation profile, right? Who's got the Worcester, who's got the clout? There are 4 types of contracts, okay? Imagine you're looking at a box that's got a rectangle that's got 4 quadrants. On the top left, we have what we call our not negotiable templates. So that's our NDAs or purchase orders or something like that. It's on our paper, we send it out. And if someone wants to supply us with water bottles, they simply sign there or they don't get it. And it's usually a feature of a very elastic supply market. The opposite of that is when we all deal with Bill Gates and his mob, or the people at SunGard, which is, you know, here's our T's and C's. We don't entertain any discussion. If you want to use our product, sign here. Now, we know that in those situations, there's no point having a playbook for the second scenario. What we need is a checklist and needs to be calibrated according to our bargaining position. You know, we can raise some major issues. We record the risk, and the business takes the decision, and we sign on. Now, there are 2 more scenarios. I'll take the least relevant one first. It's when we're involving in major sort of CapEx or custom projects, right, where it hasn't been done before, and the parties come together and they develop the contract from the ground up. You know, it could be building a power plant or something like that. Not always relevant. But the sweet spot for the Playbook application is the remaining quadrant, which is where your bargaining position is such that the deal, the transaction, the project can be consummated essentially on your paper. By virtue of your paper being in play, you have bargaining position. And most of the time, but most of that agreement is acceptable, but there will be some give or take required in relation to the key points, which are usually predictable and most of the time are the subject of our 10 key points in our utility playbook, okay? My point is this: we can't talk about some contracts it's like this and some contracts like that. We've got, when we view our entire contract portfolio through the lens of contract negotiability, we realize that our PO is one and done. We don't need any negotiation. We don't need any tool. We don't need any checklist. Load them up into the CLMS system if you've got one, and the counterparty comes on and clicks accept, and away you go. If it's dealing with Microsoft or SunGard, it's the same process, but in reverse, right? We have to comply. But where it's our paper, we can bring massive productivity along the lines that Nick's just discussed with you by deploying a playbook in support of those positions. And once that's done, or before, if you like, the idea of extrapolating, because you've got your group legal policy, tools for the custom scenario, right, or the Bill Gates scenario, you can extrapolate from your playbook, from your group legal playbooks checklists that are commensurate with the commercial implications of that deal, i.e. you are not going to get negotiations to go in your favor in most cases, but you still need to, you know, discharge your function as an in-house team and seek to mitigate risk. And if you can't budget, report what it means to the business and make your record and sign on. So I summarize this now in 3 points. Each of your business units have to work out what their 80-20 is, okay? Of the contracts that they enter into, what is the population of that body of contracts? How does it break up into those 4 scenarios? And they apply their playbook to ones where they can use their paper. If they are routinely signing someone else's paper, then they need a checklist. That's the first thing. And that's really the most important thing. So each business unit must say, you know, firstly, what's this 80-20, and how does the contracts that they work with look by reference to this 4-quadrant negotiation profile? If it's your paper, develop a playbook. If it's someone else's paper, develop a checklist.
Okay, understand. Thank you very much.
Okay, and with that, I think we've drawn to a close on the hour, and we'll have to bring this presentation to a close. So thank you very much, everyone who attended. A recording of this presentation will be uploaded to the GLS Legal Operations Center in the next 48 hours. So if you do have any friends or colleagues who you think would be interested but weren't able to attend, please do pass them along the link to that. we'll be circulating a link to that video and the sample of the GLS playbook for you to all look at over the next couple of days. And with that, I'm going to say thank you very much and have a wonderful day. Goodbye, everyone.
Thank you.